We will be resuming court in just a moment, ma'am.
Oh, I see, thank you. Which judges am I arguing in front of today?
Mrs. Edelstein, I need you to remain quiet, please. We're going to resume court. It is Judge Sias, Judge Kinsley, and Judge Nexter.
Okay, thank you.
All rise. The Court of Appeals, First Appellate District of Ohio is back in session. Please be seated.
All right, good morning. The third case that we are hearing this morning is C-240625, Pillage versus Edelstein. I see that we have Ms. Edelstein appearing virtually. Good morning. Can you hear us? You can hear us here in the courtroom?
Yes, I can, Your Honor.
All right, thank you. And is counsel for Ms. Pillage here?
Yes, Your Honor. Demetra Vikmayev here from the Hamilton County Prosecutor's Office for Common Village, the appellee in this matter.
All right, thank you very much. Ms. Edelstein, you have 15 minutes to argue this morning. We'll hear from you first and last. You may divide your 15 minutes as you choose. If at any point you lose the ability to hear us, please let us know that and we'll adjust our equipment. How would you like to divide your 15 minutes?
If it please the court, I would like to reserve 2 minutes for rebuttal.
All right. You may begin when you're ready.
Thank you. There are 3 significant procedural errors with this case that I need to alert the court about this morning. One of them is an insufficiency of service of process. A second one is a violation of my due process rights by ignoring federal ADA law. And the third one is that the decision by the trial court judge was not based on admitted exhibits, but was based on testimony that was allowed regarding personal knowledge of the allegations of the complaint from the attorney that was representing the prosecutor. So this was an improper dual rule contrary to the Code of Professional Conduct. The first one I would like to address is the insufficiency of service of process. In February of 2024, I was with Mr. Vikmayev in front of Judge Marsh of the Hamilton County Court of Common Pleas. And I alerted the prosecutor at that time that I was losing my tenancy. So roughly about a month before I lost my tenancy, I alerted the prosecutor that that was occurring. When I lost the tenancy at the end of March, the prosecutor not only knew that I was relocating, but there were also 2 sheriff returns, ultimately 3 sheriff returns, which indicated that service had not been achieved. And so when we got to the hearing in August, at the end of August, Mr. Vikmayev requested that service was deemed proper on May 17th. When he made that request, he knew that there was no proper service. In fact, the prosecutor attempted service for 5 months to multiple addresses, including 16 separate attempts after the May 17th attempt. And 2 of those sheriff's returns that came back from Marion County, Indianapolis, clearly stated that the house was empty, that there was mail piling up at the front door. The business card from the sheriff from April was still in the door in August. So this was objective and definitive evidence that was before the trial court judge that there was no service.
Ms. Edelstein, Ms. Edelstein,
That address since even before the complaint was filed.
Ms. Edelstein, I have a question. Were all those the certified mail attempts that were piling up?
I'm sorry, Your Honor. There were 3 sheriff's service attempts. There were multiple certified mail and a couple of regular mails.
So as to the regular mail, did that ever come back and get docketed?
I don't know if it it came back and got docketed. I know that I wasn't here to accept the mail, but from what the sheriff's return indicated, there was a pile of mail in the front of the front door. So I don't know if it was in that pile of mail or if it had been returned.
And Ms.
But I do not have
Edelstein,
a forwarding address because.
Ms. Edelstein, what would have been,
Because of the property distribution from the divorce bankrupted me.
Ms. Edelstein, what would have been the correct way for you to be served?
Well, Your Honor, that's interesting because the Ohio Supreme Court has said that notice of the complaint and participation in an action is not indicative to overcome this insufficiency of service. And in fact, the Supreme Court also said in another case that I don't have to do anything as the defendant. I cannot participate in my case, or I can participate in my case. It doesn't waive this insufficiency of service. But as an attorney, I was alerted to the complaint because it was 546 pages and apparently too big for the mailbox. It was sitting on the ground in front of the mailbox. It was in a ripped envelope. My neighbor, my former neighbor, took a photo of it and texted me. And that's, there was about 20 pages left. The rest of the paper, there was paper scattered everywhere. And that's how I was noticed about the case.
So Ms. Edelstein, on the hearing, in the hearing that took place, the actual, I'll call it the hearing on the merits of the complaint, you were not present, correct?
No, I was not allowed to be present. I was out of state on the East Coast, and I have a significant disability that prevents me from traveling. And so I requested an ADA accommodation, and the Americans with Disabilities Act is very clear that if you're a qualified individual with a disability, you're not allowed to be deprived from government services and attendance at hearings without the accommodation. So I requested it.
Well,
And-
Ms. Edelstein, my question is, did you have notice of that hearing?
Yes, because I attended by phone the hearing prior to that to discuss the sufficiency of service. Because again, my option was, do I participate with this or do I ignore it? And again, I wasn't going to ignore it, and since it didn't waive my insufficiency of service argument, I participated in it because I wanted to make the argument that it was insufficient service.
And in this case,
He ruled sufficient service I believe it was beginning of August, and then he held a hearing on the merits.
so how would you have had the merits, assuming you had attended the merits proceeding, how would you have had the merits proceeding go? What do you think should have happened for a merits proceeding in this particular circumstance under the vexatious litigator statute?
Well, again, I believe that look, I'm a litigator. I've been a litigator for 22 years. And if I was a vexatious litigator, you would have seen that across my career. Okay, as a litigator, we don't like to go to court and we don't like to go and argue cases. But we do it because I have a professional responsibility to alert the higher courts of abuses of discretion in the lower courts. And that's what I did. It is not my fault that the trial court judge continually abused her discretion. I tried to alert the higher courts of it, and I got pushed away. And,
Well, I'm not really, Ms. Edelstein, I'm not really asking you that. I'm asking you, in this particular case, at the trial court level in this case, how should that proceeding have taken place under the vexatious litigator statute? Should it have been in the nature of a summary judgment proceeding or in the nature of a trial?
Well, I had counterclaims, so I had requested a jury trial, but however the judge conducted it, it was a bench hearing or trial, if you will. But I would have presented evidence because in vexatious litigator, it is the nature of the cases and the filings. It's not the number of filings, it's not the outcome of filings. Again, before this federal verdict that I had, I had a 98% success rate in my motion practice, but after the verdict, I had less than 0.5% success rate. I didn't change my habits as a lawyer overnight. You know, I did not file any of my cases to harass or injure or that they weren't a good faith argument. They were. And I even went to the prosecutor prior to filing at the upper courts to talk to her about her client's behavior and to ask that this can be resolved in some other way, and they pushed me away. So I had no choice but to file affidavits of disqualification. Each of those 6 affidavits of disqualification were based on Sharon Kennedy's own law, and she had held previously that the appearance of impropriety was enough to disqualify judges, yet I had evidence of actual ex parte communications, actual misconduct, falsifying the record, pressuring a clerk not to accept evidence from me, having a court reporter falsify a transcript. I mean, I had actual evidence of this, and each affidavit of disqualification had 6 to 10 exhibits attached to it, and yet they were all denied. So again, just because the outcome wasn't successful does not make it vexatious. It's whether it was a good faith argument and the nature of the case was vexatious, and none of those were vexatious. I had 2 cases to become divorced under Jewish law, because without it, I would be a chained woman and continue to be abused by my ex-husband. I couldn't remarry under the religion. So I had to file those cases in order to be free. He refused to sign the agreement freeing me as his wife under Jewish law. The 6 affidavits of disqualification, and then there were writs of prohibition and mandamus that I filed, because again, there were instances where the judge refused to follow the law, and I requested mandamus action for that. Again, looking for the appropriate avenues is what I do, and it's what I've done for 22 years. The fact that they weren't successful is not indicative of vexatious litigator, and I would have made that argument to the judge, and I did preserve those arguments in several motions, but he wouldn't let me attend.
Which, Ms. Edelstein,
I'm sorry.
which motions did you preserve those arguments in? I understand I think you filed a motion for a continuance, and then you filed a motion for an accommodation, is that right?
Yes.
Any other motion that went to the substance of the claims?
I believe when the judge refused, or he quashed 2 of my witness subpoenas, and then told a 3rd witness when she called into chambers to ask if she could appear virtually because she was an hour away, she was told that she doesn't have to appear, and if she doesn't show up, she's not going to get sanctioned. So all 3 of my witnesses were stripped from me, so I couldn't even present a case. So when I made an argument regarding the quashing of subpoenas, I indicated that there was a legitimate basis for all of my motions, and that I'm prepared to defend those motions. I'm fully prepared to defend each and every one. They're not repetitive, as Mr. Bikmayev suggested, falsely to the court. They had different language, different basis of argument, different case law that I cited. But again, the only reason they were filed is because the trial court judge was acting in a manner that was not consistent with proper judicial conduct, proper following of the law. I mean, I've been an attorney for 22 years, and I've never seen anything like it, Your Honor.
Ms. Edelstein, so when you're talking about the trial court judge in this case, I guess this goes back to my last question. It seems like the trial court judge set this for what I think he called a final hearing.
Yes.
Assuming you had been accommodated and could have appeared virtually, was your intent to present evidence or simply argue based on the information that was in the complaint and the answer?
No, my intent was to submit evidence because 2 of the 3 witnesses, first of all, one of the witnesses was Melissa Powers, because if she is alleging in a complaint that there was improper conduct, there has to be personal knowledge to support allegations in the complaint. So there had to be someone to testify to the complaint. There was no one. And Mr. Bikmayev didn't even call Ms. Powers. There was no witnesses for his side, so I subpoenaed her to ask her, what is your personal knowledge of this?
So I guess, Ms. Edelstein,
I'm sorry, I was.
so I guess you were basically treating that hearing date as a bench trial.
That's what I was, gave the impression that it was, yes.
Okay.
It was on the merits.
Okay.
And Ms. Edelstein, you're out of time. Miss Edelstein, I don't know if you can hear us. You're out of time.
I'm sorry.
You're out of time. I'm sorry. I think when you're speaking, the equipment has trouble relaying what we're saying in the courtroom.
Yes, I apologize.
That's all right.
Waking up.
Yes, that's all right. You're out of time, but we'll come back to you to use your rebuttal time in just a moment.
Thank you.
Thank you.
May it please the court, Dimitri McMayev here from the Hamilton County Prosecutor's Office, here for the appellee in this matter, Connie Pillage. I'd like to address some of the things Ms. Edelstein mentioned in her presentation. She informed the court that she was in the process of losing her residence in April of 2024, not February as she claims. That was in case A2401680. That doesn't inform us that she is no longer there.
Would your position be that the regular mail was sufficient based on the return of the regular mail?
Absolutely.
And that's consistent with Ohio law?
It is. So certified mail went out, came back unclaimed. Regular mail went out in accordance with 4.6D. And there was a certificate on the docket showing that this was mailed. There was no return for any reason of the regular mail.
What about, doesn't it seem like an odd procedure below to just set this for a quote-unquote final hearing? It wasn't even a bench trial. It wasn't set as a bench trial. It was set as a final, it was set as a hearing, right?
Right.
So how would someone know that this was going to be basically a trial on the merits?
Specifically with respect to Ms. Edelstein?
Yeah, or anybody.
Well, because she was at a hearing on August 29th where this was set. She was in consent for this hearing to be set on 9/26 when we argued the service issue.
Well,
But this didn't follow like an actual civil case. I mean, there wasn't a scheduling plan, there wasn't an opportunity for discovery. I mean, this just sort of was fast-tracked into this final hearing that wasn't actually called a trial, right?
It wasn't formally called a trial. I assume once service was established and, for the purposes of establishing Ms. Edelstein as a vexatious litigant, we feel like the best evidence are her filings, which were certified and
Well, were
submitted.
those actually taken into evidence? I mean, I know you filed a notice of exhibits, but did the trial court ever actually take those exhibits into evidence?
I would consider it a part of the record. What Ms. Edelstein has noted is it's not denoted in CMS as an exhibit that was maybe formally admitted as an Exhibit 1, but as a certified court filing, which is self-authenticating and which is available for the trial court and for the judge to review, and on which argument was made at the hearing, we would argue that there was evidence and these self-authenticating exhibits were the evidence.
Should it have done that before reaching a merits determination? I mean, should it have actually taken into evidence the exhibits that it was considering as part of its judgment?
We feel as though because Ms. Edelstein wasn't there, it would be kind of fruitless for us to go and identify exhibit by exhibit.
Why is that?
Isn't that what would happen in a regular trial when someone doesn't show up to defend? The proponent would submit evidence, they would be entered into, in the absence of just granting a default. Like if you actually wanted to make a determination on the merits that wasn't a default determination,
Sure.
you'd take that into evidence as part of your record. Were they actually submitted to the judge? Like
Yes,
how?
they were.
And
Yes, the
did
judge
they,
was
were they,
provided a
were they
binder.
given to the court reporter and said these are entered as exhibits A through, whatever?
A copy of all of these filings were presented to the judge in a binder, and I do not recall if they were given to the court reporter, but they were presented to the judge, and then an argument was made as to the applicability of those exhibits as to.
And what if
Ms.
our
Edelson's
record, I mean, I take you at face value in your representation, but what if our record does not reflect that? What if our record does not reflect that a binder of exhibits was taken into the possession of the trial court?
I'm not sure if I'm in a position to speak about that. Being at the hearing, I know that we handed the judge a binder full of these exhibits, and I know they're also part of the record for him to examine, even if that wasn't the case.
Is that how an ordinary civil case would proceed, with a party filing a notice of exhibits and then a trial court reaching a judgment without taking any exhibits into evidence? Is that ordinary?
That's not ordinary, but I wouldn't classify this as that happening, given the fact that these were available on the record and that they were handed to the judge.
It seems like the court treated this as kind of its own category of case. In your research of vexatious litigator cases, are most of these determined by motion for summary judgment, or are they determined by trial? It seems like this is something that would probably be determined at the Rule 56 stage.
I would say 2/3 of the cases that I've reviewed have gone on a motion for summary judgment, and about 1/3 were probably brought by the prosecuting attorney to designate someone in that jurisdiction as a vexatious litigant like we did in this matter.
And a Rule 56 motion would give the opposing party an opportunity to respond in writing and to submit their own evidence if they chose to, and also to conduct discovery if they chose to, or to seek 56F extensions and all of the procedures that the civil rules allow, right?
Yes, it would.
And did any of that happen in this case?
Officially, no, it did not. But the fact is, Ms. Edelstein chose not to attend this hearing when she was privy to the scheduling of it.
So she was privy to the scheduling of it because she was at that first scheduling hearing. She was present on the phone, is that?
She was, yes.
And at that scheduling hearing, what was the nature of the scheduling? Was it, I'm going to have a bench trial on date X, or was it, I'm going to have a hearing on the merits on date X? Because what was the merits at that point in time?
At that point, I think the August 29th hearing was on the merits of the complaint.
Of the complaint?
Yes.
So the complaint had been, the substance had been denied by the answer.
It had, yes.
So, I mean, in the absence of a motion for summary judgment, were you treating this as a bench trial?
We were treating it as a hearing on the merits. I assume the trial court could have interpreted that as a motion for summary judgment.
It just seems like an odd procedure.
And what about the
Maybe.
counterclaims? What was anticipated with regard to the counterclaims? Because a possible outcome, I mean, all outcomes were possible heading into this final hearing. And a possible outcome would be that the claim brought by Ms. Pillage was denied, and then the counterclaims would need to be resolved. So did you have witnesses ready to defend against the counterclaims at this hearing?
We were never served with the amended answer that
Well, did you
included-
need to be? Because it could just be provided to counsel. I mean, this was a subsequent pleading.
I don't recall if Ms. Edelstein ever forwarded that, her amended answer with the counterclaims per se, considering that she did, the counterclaims that she did incorporate in that amended answer were mostly defective, outright defective, not recognized as something that can be brought in a counterclaim.
Well, had you filed a motion to dismiss the counterclaim?
We did, Your Honor.
And was that pending as of the time of the final hearing?
That was filed after the first judgment was put on, but before the amended judgment was
So
put
the-
on, where her counterclaims were officially dismissed.
All right, so the counterclaims were live I understand that you may have had defenses that you wanted to raise to them or issues that you wanted to bring to the attention of the court, but they were live as of the time of the final hearing. Did you have witnesses ready to defend against those counterclaims at the final hearing?
I don't believe we had notice of the counterclaims at the final hearing on September 26th.
You didn't have notice, wasn't the answer filed?
That may be the case. I don't recall on the timing of the docket at this point.
It seems like a very compressed procedure. From the time of complaint to the final hearing, how much time elapsed?
So from April until the end of September. But for this purpose, these people that Ms. Edelstein subpoenaed, this isn't relevant. Her subjective opinion of her filings isn't relevant to the determination of whether she's a vexatious litigant or not.
Well, one of the components of being a vexatious litigator is the intent or reason for why they were filed. And certainly a person facing a vexatious litigator complaint might desire to defend against that by presenting the reasons for why they filed various actions. Would you agree?
Certainly, and I think that's why Ms. Edelstein should have showed up to the September 26th hearing that she knew about, and so that she would have an opportunity to defend against these claims.
So you told us that 2/3 of the cases that you looked at were basically in the nature of a motion for summary judgment. The other third, are they cases brought by the prosecutor? Is that what you're saying?
Yes.
And were those cases, how were they dealt with or determined? Were they not motions for summary judgment? Were they something else? Were they motions for judgment on the pleading? Were they bench trials? I'm just wondering if any court has used this procedure that was used below here.
I don't recall off the top of my head at this point. Most of these vexatious litigant determinations, probably 2/3, like I said, were a motion for summary judgment in some matter.
It almost seems like a declaratory judgment.
A bit maybe, perhaps, yes.
And what about this third witness? So I understand there were 3 subpoenas issued by Ms. Edelstein. 2 of those were quashed, but 1 was not. She has raised an issue of a communication with the trial court judge's staff. Is that represented in the record? Can you shed any light on what occurred with respect to the third witness?
I'm not I cannot recall the third witness that Ms. Edelstein is referring to. I will tell the court that, so we had a month approximately between when this hearing was set and the date of the hearing. Ms. Edelstein waited 3 weeks to issue these subpoenas. Because of that, they were untimely. 2 of the people she subpoenaed asked for these subpoenas to be quashed given the untimeliness. The one you were referring to may be someone from Women Helping Women that she subpoenaed. I don't recall any communications with the trial court. I don't recall seeing that on the record here.
All right,
That
so-
may be the case, but
So there was a witness that had been subpoenaed, and that subpoena was somewhat unresolved as of the time of the final hearing?
that may be a fair classification, yes.
All right.
Also, Ms. Edelstein has referred to asking for a jury trial. She's not entitled to a jury trial on this. Her arguments as to the witnesses, I feel like those are waived because she did not appear at the hearing. She takes issue with these witnesses not appearing, but then you don't show up. I feel like that's a waiver of that complaint because she did not show up at this hearing. I will also say the fact that she was denied from appearing, which is what she has referred to, that's not on the record.
So are you arguing that the counterclaims were properly dismissed because they weren't prosecuted at the final hearing? Is that your argument?
I think they're outright defective to begin with. I don't believe any of the claims, for the sake of argument, are valid under Ohio law. I think Ms. Edelstein chose a couple of words that sounded nice and included them with her amended
Did the
answer.
trial court make that finding?
In the amended judgment entry, it did, Your Honor. It dismissed them. I'm not sure if there's a finding that's.
Do we know why? Like, is it 12B6? Is it failure to
No.
prosecute? Do we know why?
I cannot say.
Is another plausible interpretation that the trial court dismissed the counterclaims because the vexatious litigator finding meant they needed leave and Ms. Edelstein had not sought leave at that point?
If they were valid and not outright defective, I think because she was deemed to be a vexatious litigant, they couldn't stand in light of that judgment.
Is the vexatious litigator statute, is it in any way in the category of a special statutory proceeding?
I am not certain, to be honest.
And is there anything in the statute that dispenses with the civil rules?
There is not. It says that the proceeding will move forward as a typical civil matter. Briefly on Ms. Edelstein's disability accommodations, judging by the record, all we have to substantiate this disability is a handwritten note from September 2023 from an urgent care in Indianapolis, Indiana, that says that Ms. Edelstein cannot sit for an extended amount of time. I would tell this court that I think there has to be a nexus between the disability and the accommodation that one is seeking. Given the fact that Ms. Edelstein was in Indianapolis or maybe Cincinnati, we don't believe that that disability would preclude her from appearing, would prevent her from being able to appear in person. The fact that you can't sit for an extended amount of time doesn't mean that you cannot travel to the court. It doesn't mean that you can't conduct yourself in a court. You can certainly stand periodically. This note is also not authenticated. We don't know who wrote it. The trial judge is also.
So how would she travel in a mode that would not require sitting?
Well, she could travel and take periodic breaks to stand, I would assume. We argue that she's in Indianapolis, going back to the service issue. Her filing in this matter on June 13th, when she's contesting the venue in this case, she says the proper venue for this hearing, for this matter, is in Marion County, Indiana, where the defendant resides. She kept using this address up until the point where we made the argument that we asked for the trial court to establish that service had been obtained because no regular mail was returned. Given the
If all that was going to happen at this final hearing was the introduction of a binder of exhibits that you had already filed and served on her, what would be the problem with her appearing virtually for such a proceeding?
I don't foresee that there would be a problem, but she didn't appear.
Well, I believe the record reflects, and I believe she has argued that she attempted to and was told that she could not by the trial court.
I'm not privy to that. I did not see Ms. Edelstein in person, and I did not see Ms. Edelstein on Zoom. I find it hard to believe that she was prevented if she called in.
Well, she requested ahead of time, and the trial court declined. So what would have been the reason for the trial court denying that kind of an accommodation, given that the hearing was going to be to move pieces of paper into evidence, which actually didn't
Well, I'm sure
wind up
Ms.
occurring?
Edelstein would have had an argument to counter that, movement of certified authenticating filings on her behalf to various area courts. I'm not sure why the court wouldn't allow her to appear. She appeared at the prior hearing. I would say that the trial court has afforded wide discretion to gauge her credibility. She did not appear with her camera on at prior hearings. Maybe that played into this determination. It's hard for me to say.
All right. Thank you. You're out of time. Thank you very much.
Thank you.
Ms. Edelstein, you have 2 minutes remaining for your rebuttal.
Yes, and I apologize for the short time I'm going to go through multiple things, but this was not only set for a final hearing. I was told it was going to be on the merits. The statute does provide that vexatious litigator claims have to follow the same course as regular civil actions, but yet not only did he set the final hearing within less than 30 days, I had no opportunity to conduct discovery or depositions My witnesses were excluded from it, and my witnesses were the prosecutor, because I did make attempts prior to filing the writs and the affidavits of disqualification to settle this matter with her directly. And I spoke to 2 people at her office in 2 separate attempts to try to settle this. Then my second witness was another person from the Supreme Court who I had tried to settle this matter before filing my affidavits of disqualification, and I couldn't get any relief. And the third witness was a former domestic relations magistrate who was going to testify about whether the nature of my filings were appropriate given the conduct of the domestic relations judge, and what I was seeing with ex parte communications and a variety of things that were improper. So I did have witness to address the merits of my case, and it is reversible error that he did not, he based a decision on no exhibits, that he admitted that it's a significant right that's taken away from someone, especially an attorney. I can't afford to have anyone represent me, no one will represent me. And so, you know, it is reversible error that he failed to review any admitted exhibits before issuing his decision. And as you can tell from the shortened time period, my due process rights were violated. I didn't have an opportunity to conduct even a defense, let alone the counterclaim, which did have merit, contrary to Mr. McMahon's allegation. And I filed an amended complaint with the counterclaim to allege that the complaint was frivolous in and of itself because it was unsupported. It was completely unsupported by personal knowledge or evidence.
Ms. Edelstein, you're out of time. Ms. Edelstein, you're out of time. Ms. Edelstein.
Madison County to the Supreme Court in a separate affidavit of disqualification. He was ordered by the Supreme Court to step down and not preside over my case pending the review of the disqualification. And instead, he issued this vexatious litigator entry, and then I have evidence that he backdated it.
And Ms. Edelstein, you're out of time. I'm not sure if you can hear me.
Did not show his entry. And then he issued the entry several days later and backdated it
You
to
sent
make
her
it
a
look as
note.
if he issued it before the disqualification
Can you send
occurred
her
and before he was told to step down.
electronically?
Can we send her a chat and let her know
Yes.
that
These
we're out of
type of
time?
shenanigans, this shortened procedural thing, the quashing of my witnesses, the preventing of my counterclaim.
Ms.
Ms.
Edelstein,
Edelstein, you're out of time. And we appreciate your arguments this morning. We're going to conclude the argument. Thank you very much for your presentation. We're going to take the matter under submission and issue a timely decision. Thank you very much for your arguments this morning. Thank you.